Okay, so really quickly, welcome. It's November 13, 2025. We're mastering the new ex parte order rule with Lori Buiteweg. I'm not going to repeat my introduction of her because all of you already know who she is. I just was a little slow in hitting the record button. My bad, sorry. So what we're going to do today, first of all, anything that Lori or I say is not the view of the State Bar of Michigan or the family law section. We're like just regular family law attorneys trying to figure things out, just like all of you. I wanted to talk a minute about the background. Hello, Lori, by the way, if you wanted
Hello,
to say hi
Lisa.
to
Thanks for
everybody.
having me today.
I'm going to talk for a minute about the background of how I think this rule came about, just my suppositions. And then we're going to talk about a few different ways ex parte orders come about. The first two things we're going to talk about won't take up very much time. And then we're going to really get to the meat of it, the custody ex parte order. So just hold on tight. It might take us 5 minutes to get there, but I think we will get there. And it's going to be spending a lot of time talking about really the heart of the new ex parte order rule or the amendments to the rule. So just by way of background on the ex parte order rule, what I see as an appellate attorney is there's been a lot of reversals on appeal of the trial court by the Court of Appeals and sometimes even by the Supreme Court of trial court orders that enter an ex parte order that ultimately changes custody on an ex parte order that based on allegations, which is obviously how that works on ex parte. And the hearing, instead of happening within 14 or 21 days, the hearing would basically start maybe 6 months later and then take a year, the typical what we see in a lot of post-judgment custody matters. Anyway, there's been just a ton of reversals in this one area. And I don't know this for a fact. This is just me hypothesizing. But I think the Supreme Court was like, why do we keep seeing all these appeals where we have to keep on reversing because the rule isn't being followed? And there's all this case law that had been developed, both published opinions that laid out exactly the steps of how to apply the rule. And it just wasn't being followed. So my theory, and again, it's just a theory, is that the Supreme Court, because some of those cases did make it to the Supreme Court, kind of got their attention. And it wasn't just the ex partes. It wasn't just that there were ex parte orders changing custody, but there was a lot of delays, as we see in family law cases, to actually get to hear, not just start a hearing, but then to get to the finish of a hearing in a post-judgment context. A lot of times it takes a very long time. And I think we've also seen a lot of inconsistent practices around the state. So it might be one thing in Ingham County where I am or Washtenaw where Lori is, completely different if we're out on the west side of the state, Oakland County, and you like without like, and it's really not supposed to be that inconsistent, right? Like that's why we have rules and case law. It's like to make the law consistent around the state. So what happened this past year was the Michigan Supreme Court proposed an amendment. I know Lori and I talked about it quite extensively, and then we talked again with the family law section about some things that the Supreme Court was proposing and things that we thought should at a minimum be tweaked. And ultimately, the Supreme Court made their own changes and issued a rule that only became effective September 1st of this year. So that means we don't have any case law yet, and we will at some point. But right now, all of us are kind of working in this vacuum of the trial judges are dealing with the rule for the first time. The practitioners are dealing with it the first time. So that's kind of the whole background of what we're talking about. Now, to start the ball rolling with Lori, and we definitely want to hear a lot from Lori today, we talked about different contexts in which ex parte orders are used. And the last one we're going to talk about is custody. So Lori, can you take it off and take us away and tell us a little bit about the different like phases of cases where we see ex parte orders?
Absolutely. Thanks, Lisa. And I think that one of the big reasons why we should be paying so much attention to this, to ex parte orders, is because of the tenuous due process, element of it in the beginning. And why, as you mentioned, having a resolution that takes into consideration both sides' perspectives and facts is so important to do that in a speedy manner. And because we don't want to disrupt children's lives unnecessarily, that's the public policy behind the Child Custody Act of 1972, is that we're not going to, disrupt children's lives unnecessarily. So on the other hand, we need to protect their littles. So So we have these competing interests going on. We're really, with this rule, we're trying to thread a really important needle here. So, the way that ex parte orders come into play, as you mentioned, can be different from one county to the next. And in some counties, for example, financial status quo, mutual financial status quo restraining orders get sort of handed out. I've heard the phrase like candy.
Right at the beginning of a divorce filing, right?
Yeah, right at the beginning. And, whether or not the pleading is verified, that, the pleading that requests it is verified, whether or not it actually alleges irreparable injury, loss, or damage will result from the delay required to effect notice, what are the actual facts? So I think courts are looking for, make sure that your petition is verified, that it is separate from a complaint for divorce, for example. You're not going to bury the allegations requesting the ex parte order in the complaint for divorce. You're going to file a separate motion for the ex parte order, and you're going to allege actual facts in your verified pleading that your client signs that show this irreparable loss or damage. For example, spouse threatened to, remove money from the bank account and hide it in the Cayman Islands, or, a spouse is trying to sell the marital home that's in their sole name, even though it may very well be a marital asset, it's in their name, so they can sign the listing agreement on there, something like that. Not just, oh, my client is afraid that they're going to move money. Okay. So it depends on, I think, the county, what they do with those, but the rule of law is verified pleading, and you have actual facts to back up the requirements. Then, of course, we see the ex parte orders that are requested early in the divorce case, maybe with the filing of the complaint for divorce for custody and parenting time, maybe even child support. And then you've got the ones that happen sort of in the midst of the case. And then you've got the requests, the motions that happen, of course, post-judgment. And regardless of where your request for an ex parte order falls in the spectrum of the case, or the longevity of the case, you're going to be, of course, held by the same rules that we have now. And so I think the main thing about the new rule, there are a couple main things about the new rule, but as you mentioned, there were so many Court of Appeals cases where trial court judges were getting reversed because they were changing custody without determining the established custodial environment and without determining what burden of proof was necessary. Of course, if you're changing the established custodial environment, you need to allege that there's clear and convincing evidence to do that. And just as a little refresher, established custodial environment is defined in MCL 722.27. The custodial environment of a child is established if over an appreciable time the child naturally looks to the custodian in that environment for guidance, discipline, the necessities of life, and parental comfort. So if I'm filing a motion for an ex parte order, I'm going to address each of those elements of established custodial environment. If you want a little more.
Yeah, I think this is a good time for me to throw up the language of that part of the new rule about making your motion for ex parte. So give me a second. You can keep on talking. I'm just going to throw up and make sure everybody can see it. Can you see it, Lori? If you can see it, everybody can see it.
I can see it.
Okay, good. So this is where we're talking right now, 3207B, and we're talking about the first part of the court rule, that is when you're the one that, is making the motion for ex parte relief. And you can see kind of getting into what Lori's talking about. This is all new language. Go ahead, Lori.
It is. It's all new language. If you're looking for a little bit more meat on the bones to beef up your affidavit, your motion for ex parte, you can always look at the Berger case, which is 277 Mishap 700. Okay, what's your next question, Lisa?
I was thinking we do a polling question really quickly. We have a few
Sure.
polling questions. I don't know if I need to stop sharing in order for, do you see the polling question?
I do.
Okay, good. So how much detail do you think that the court rule should require? Laura, you and I can't vote, so this is just for everybody else. At least one fact to support each of the elements of the ECE, or a detailed affidavit laying out the ECE facts, or a description of parenting time schedule to show how much the child is looking to one or both or neither parent, I guess, during parenting time. And we'll just give it a second to, I still see a lot of votes coming in, so I don't want to shut it off prematurely. Still people are bouncing around. You can't see can you see the votes?
No.
Okay.
No,
so
but I can still see the screen, which may hint at what the answer might be.
Okay, I'm going to share results. Can you see the results? 45
Yes.
out of 70, 64% of the people who voted detailed affidavit laying out the facts.
Yep. I agree with that, don't you, Lisa?
Yeah.
Yeah.
I mean, I'm just looking at the court rule. It's talking about, you have to set forth, does it say affidavit? Yes, it does.
It says facts plural.
Pleading, verified pleading, or an affidavit, facts establishing whether the child. I think it'd be helpful. You just read to us what an ECE is. What are the facts that show the child looks to the parent for guidance? What are the facts that show that the child looks to the parent for discipline? What are the facts that, like, kind of go through mentally? And maybe you don't have something on every single one of those, but you kind of think of, this is what the standard is. It has to be for an appreciable time. What does that mean? Oh, okay, they've been the primary physical caretaker for the past 3 years. I mean, there's a lot of things that go into the ECE. It's not just the number of overnights. Even though I think a lot of times the judges at the Court of Appeals, they would love to be like, just have a bright line rule, and there's just not one. That's just the way it is.
No, because just because you have parenting time doesn't mean you're actually with your child.
Right, exactly. Yeah, exactly.
Yeah.
So also facts establishing the entry of the order will either not change the established custodial environment, or if it is going to change the established custodial environment, is it supported by clear and convincing evidence that it's in the best interest? So this is where we're getting, right, the affidavit and the motion are going to have to be way more detailed than what we've seen in the past. You showed me a sample order that a judge had created because there isn't a scale form yet. But I can't imagine a scale form, like any scale form is going to have attachments like this. You cannot put all the details that you need to satisfy this court rule into a scale form. And I mean, that's okay, as long as you have the attachments to go along with it, and obviously verified attachments. So,
and an affidavit, maybe an affidavit or verified attachment.
yeah.
I wanted to point out, Lisa, if I can jump in here.
Yeah, for sure.
That under A sub I, it does, specify whether a child has an established custodial environment with either parent, both parents, or neither parent, which is also a third party, right? I mean, usually if it's neither parent, it's because the child is with a third party, but sometimes it's because there's just been so much litigation and the children have been bounced around so much that they just really don't know which parent they're supposed to be kind of looking to for all of the elements of an established custodial environment. I wanted to just throw out this citation for your audience in case they're looking for an example of a case where the established custodial environment is with neither parent. It's LaFletch versus Ibarra, 242, Mishap 692. It's kind of an old case, but it gives an example of some kids that are with a grandparent. So that's something to think about, because the neither parent part wasn't in this originally, but then as the Supreme Court kept developing it, I think they added that in there.
Right. Now, I think this part is pretty straightforward, right? It's more work. It's more work for the attorneys on the front end,
but
which
we
is
can
good.
do it.
We can do it, and that helps the judges. Like,
it does, and it helps the kids, and
it's also like, suspending parenting time may be a change of custody. Just because you call it parenting time doesn't mean it doesn't change custody. So I
Yeah,
think where we're going to get a little bit more, I'm going to scroll down because we're going to get to the next part of the
yeah,
court rule, which is also all new.
yep.
And it's going to start getting more complicated now. So this
Yeah,
is the
and I don't
section.
know at
Go
what
ahead.
point you want to, people are asking for that citation on LaFletch again. It's 242 Mishap 692.
I might have
Um,
to stop sharing in order to put something in the chat at this point. I don't know how to do
oh,
it.
well, I just
Okay.
said it, so
Okay.
they should
Okay.
be okay. Or they can email me later, but
Yeah.
I don't know at what point you want to put up our flow chart, Lisa.
Um,
Later?
in a minute. Yeah.
Okay,
Yeah.
okay.
Lori made a really beautiful flow chart that compares the parenting time statute with the court roll. And I think we can circulate if you're, as long as you're okay with it, Lori,
Oh,
we can
yeah.
circulate it with takeaways after the fact. So like maybe early next week, just in
Yep.
time for us all to be at the Family Law Institute together. But this, okay, part B, this is the section about what what the court's allowed to do, right? The court
Right. Well, I
must
think
not
the
issue.
first thing,
Go
now that
ahead.
you've scrolled down, that we want to focus on that wasn't there before in either the statute or the court rule is that you have to serve the ex parte order within 3 days of when it's issued. It doesn't say 3 business days, it says 3 days. I don't know about the rest of your audience out there, but I have a lot of trouble finding a process server who will get something on a Friday afternoon and have it served by Monday afternoon, you know? So this is a challenge. So when your clients come to you and say, the sky is falling, I need an ex parte order, you might want to think about, when is the court's next regular motion hearing? And are you kind of better off, just filing your motion on the regular docket and, serving somebody, by first class mail if they've already, acknowledged service and have an attorney. But if this is that you're doing this with the filing of your complaint, and therefore you have to have, personal service, like, just think about that and remember that. The other thing, one thing that bothers me about this rule is that you're not required to serve the motion, just the order, right?
Right.
That's what it says,
Yeah.
right?
Yeah.
So how do you know what to say in
Yeah.
response, to the motion if you don't have it? But presumably, once you get served with the order, you're going to obtain the motion somehow or another, either calling opposing counsel
I,
or going
yeah, I
in.
do have a question for you about the service within 3 days. Is that just apply, that applies to any ex parte order, right? Not just
Yeah,
custody orders changing custody, because a lot of times ex parte orders are entered at the time a divorce complaint's filed, and there may be safety reasons that an attorney delays serving the complaint and the ex parte order that goes along with it, because you've got to make sure the client can be in a safe, have a safety plan. I
right.
mean, I understand that if it's an order changing custody, it's like we're talking about like the middle of the case or the post judgment proceeding. Yeah, you should, obviously I think the 3 days makes sense, and I understand the burden that it puts on when you get a Friday order. But like if it's a beginning of the case, I'm not even sure how realistic that is to get the
Yeah,
whole everything served, and you may not for safety reasons not want to do it that quickly.
yeah,
I don't
yeah.
know.
Yeah, yeah. Well, and you don't have to comply with the next party order until you're served with
Right.
it.
Fair point.
So anyway, okay. Well, I just wanted to point that out. Um,
Right. So moving to the court, if the court is going to grant an ex parte that changes the child's established custodial environment, obviously relying on those allegations and pleadings that are in front of the court, they also have to schedule an evidentiary hearing. So this is definitely new. This is it's what was in the case law. Well, it was in the binding case law, but this is kind of memorializing what we've seen in all those line of cases. You have to
yep,
schedule an evidentiary hearing.
right. This is a good time for that poll.
Oh, and then you have to have that hearing within 21 days. Okay, so let's do polling question number 2. Prior to this court rule change, how many of you were in counties where the judge scheduled the hearing when it entered an ex parte order, so that you would know when the order was entered that you have a hearing date coming up at some point in the future?
I am really curious to see the
Me
response.
too. Me too. And I'm gonna give it like another minute because the votes are still coming in. Over
And then while
50%
people are
people.
voting, there's always the case where the judge might deny the ex parte order and invite you
To have it, right.
to put it on the regular motion
Yeah.
docket,
And that's okay too, right?
Mhm.
To the extent that you're in a county, like some counties are really good. I'm gonna end the poll. Um, and share the results. Some counties are really good, like in Oakland County, you pretty much can count on the judge having a motion call day like every Wednesday, unless that we know they're going to be out of town. So you don't have to wait that long. But other counties are not like that. So
I know.
you might have to wait for 3 months to get your hearing, your motion heard. Then you're going to have to
Yeah,
file an emergency. So
which brings us to that point we were talking about, Lisa, where, like, what if the courts had an ex parte docket, right? Kind of like they have a PPO docket.
yeah, yeah.
I think that might be kind of a cool idea. So what did people say? Once in a while was the majority.
Right. But 32% of the people said never.
Never. Yeah, that's why you have all those cases
Yeah.
that are reversing and remanding and vacating, and yeah. Yeah.
And I'm curious about the counties that do it frequently. 12% of the people said that they are in a county that does. It could just all be one or two counties. So,
Could be.
um, all right. So they have you scheduled the hearing at the time you sign the ex parte order. That's good. And I've talked to judges, and it's like for them, it's helpful that before they sign the order, they're looking at their calendar to say, okay, this is when I'm going to fit it on my schedule.
Yep.
And we're going to put it on it's going to be 15 days from now, but that's when I have time. I'm going to block this time for this case because I'm going to have the parties come in then. So that kind of makes sense. The judge is doing that. It's going to like, they can do it based on their availability, which I think is helpful. So then we move, I think, what happens when you've received the ex parte order and now it's your client has to do something. So this is where it's going to get complicated. I think we should do the polling question first. Let's do polling question number 3, and then we're going to start talking about what the rule says.
Oh.
Is there a difference between an objection to an order and a motion to rescind an order?
Well,
No, they are
okay.
effectively the same. Yes, they are different. They have different names. Yes, they have different names and procedures.
Right. Now, I would say leave the poll open for a while we talk and let people read this part, because
Yeah.
we're looking for the answer to this question in the context of the new rule, right? Not like
Well,
what you thought before the rule was.
Well, I think the polling question was intended like without like looking at the rule, did you think there was
Oh,
something different? That was kind of like the impetus behind it.
okay,
Um,
okay, okay.
but
Then
a
don't
lot of
look at the rule before
but a
you
lot of
vote.
people may have already read the rule. So uh, I know we received some emails from people who are studying the rule before this. So I'm going to end the poll and share the results.
Okay.
And I think so now I don't know if people are answering because they've read the rule and they like, yeah, I think they're different.
Yay.
I mean,
I
I don't
am
know. Do we think
absolutely
they're different?
thrilled.
Yeah,
I am
we
thrilled
think
with
they're
this
different too.
result. Yes, because because when they were, making the sausage, so to speak, I was really hoping that there would be a way in which, as practitioners, we could avoid the friend of the court intervention if we wanted to and just stay with the judge for a few reasons. And I think the way this reads and the way I read it is, if you file a motion, you're going to stay with your judge. If you file an objection, you're going the other track and you're going to friend of the court first. Um, so
And why, but why would you want to why would you want to do that? Like, wouldn't you want, and
Well,
I
there's
think,
reasons, right? You got
yeah,
to think
right.
it through. There's strategy, right?
Yeah.
I might want to stay with my judge because I'm the moving party and it was granted. And so I think I'm going to, well, if I'm filing the
You're
objection,
the
then that's not
objection.
my choice. So maybe I want to go to the friend of the court if I'm the one objecting, because maybe I'll get a different result. But let's be honest, how likely is that? I
Yeah.
mean, the friend of the court's boss is the judge. So,
Right. Right.
and I'm thinking that I mean, if you're a referee and you have an ex parte order from a judge, you know the judge thought it met the irreparable harm standard, right? And so you may not know what the judge exactly was thinking about why the motion met the standard, but you know the judge felt that it did, believed that it did meet the standard. And so kind of as the referee, you're trying to find those reasons. You may be a little bit biased in favor of keeping the ex parte order in place because the judge issued it, right? On the other hand, maybe you know this referee and that's your personal strategy, right? I mean, you've got to decide, like, I think this referee isn't necessarily going to do just what the judge did. They don't always do whatever the judge did. So now I want to do an objection so I can go to a referee and maybe get a different opinion. But you know, if I want to stay with the judge and avoid being sidelined to the front of the court, I'm going to file a motion. That's how I'm reading these. And I don't know, it seems like 81% of your audience
Right.
agrees.
And I want to apologize to the audience because when I pulled up the screens, my questions and chats all went to a different monitor. And I see that there's been a lot of questions and commentary about service. We'll come back to service in a little bit. I just wanted you to know that I did find those questions and chats. I was wondering, Lori, to your point, if you're the party objecting, I mean, I think most people I've talked to, including judges and attorneys, likewise, they would prefer to have the judge who granted the ex parte to be the one to hear the objections. I mean, maybe it's psychological, like you granted this on these allegations and look, they're all wrong. You weren't told the truth. And that's going to be more impactful to the judge who, you know, was convinced to grant it, maybe,
Yeah.
and there wasn't
Yeah.
enough there because they what they provided wasn't like.
Well, and also if you think about the tenor of an ex parte motion, right? I mean, these are folks who are just not getting along. They're not communicating. They're not agreeing on things. I mean, really realistically, what are the chances, right, that going to the front of the court is going to resolve things? Isn't this something that you really probably are going to end up having a judge decide anyway? And then it's just going to cost your client more money to have to go right to the front of the court first, although they do have some provisions in here for pro pers. So,
Right. And I'm about to bring up your chart, Lori, because I think it really highlights some of these differences. But the other thing I wanted to point out was the timing. We added up the timing. Like, okay, the court has to have the hearing within 21 days. That's when they sign the order. And then if you file a motion to rescind, the court still must hold it within 21 days of the motion to rescind, but it's already been scheduled. It's already supposed to have been scheduled within 21 days of the order in the first place. So now is your hearing delayed? No, probably not. Probably what the judge is going to do is going to accept your motion and then have the hearing that was already scheduled. But if you go to this other track with the objection, they're canceling your hearing because you're going in front of the FOC. And Lori and I plotted it out from like January 1st, ex parte order, ex parte motion filed or ex parte order signed to get to through the whole process of the days, counting them up to get before the judge and when the judge has to make decision. It was like the middle of March.
yeah,
Just using the timeline. So
yeah.
I'm going to stop the share of this screen for 1 minute so that we can look at this chart. Second to pull that up. So the chart that Lori so brilliantly came up with is.
And kudos to your Jacob for making
Yeah.
it look lovely.
Jacob made it look beautiful. That's what he does. I give him stuff. He makes it look beautiful. So it compares the parenting time statute, which talks about going to the FOC, with the court rule. I mean, I have a few more thoughts about that, but you can see there's differences between when it's purple, there's differences between the statute and the court rule. When it's orange, they're the same. And there's all these deadlines that are in here.
And one of the things I want to jump in and say about the statute is that it has procedural court rules embedded in it, which is not how it's supposed to work, right? I
Right,
mean, statutes aren't supposed to tell the courts how to process their
right.
cases and do their job in that way. So, normally what we're doing in our public policy forums is we're making sure that the court rules are in line with the statutes, right? But in this case, the court rule kind of goes way above and beyond what
Hmm.
the statute says you have to do. So is adding more meat to the bones in the court rule a problem for us from a legislative rule of law point of view, or is it okay? Anyway,
Yeah, I
it's
mean, so I've been thinking about this a lot because I think and I'm not calling out anybody specific, but my general sense is that there are some judges who think maybe we should tweak the rule to not have it go to the FOC. And then the question is, well, is that somehow violating the statute? And I have my own thoughts about this, and I've been thinking about it a lot in the past few weeks. Like you said, the legislature is not supposed to be governing procedure. They do substance. And here
right.
in 72227A, they've definitely kind of dived into the procedure by having all these days. I mean, on one hand, this is only regarding parenting time, the statute. It's not governing custody, it's not governing child support, all the other things affecting children. So on one hand, you can say, well, it's kind of limited, but I think the way you were approaching it, Lori, of like looking at it as two tracks and you just pick which track you're going to be on, then maybe it doesn't matter. Like, okay, if you don't want to go in front of the front of court, then don't file an objection.
Mhm.
Maybe you don't have to file anything,
Well,
obviously,
too, and
but
as I recall, if there is a conflict between procedural, process between a statute and a court rule, you go by the court rule.
right,
Do you agree
exactly.
with that? Yeah.
Yeah, no, I do agree with it. And that's kind of where I was like kind of resolving the conflict that's
Yep.
created here.
Yep.
And it's not really created because the 3207, what the Supreme Court does follow, it tracks
Yep.
in many respects the statute. But
Right.
if the way it's written today is really causing a lot of problems, not just for attorneys and families, but also for the judges who are sitting on these cases that would like to have it handled a different way, and we all kind of agree on that, then maybe there's a way we can talk to the Supreme Court about it. One thing I wanted to, there's one of the questions in the Q&A. SCAO Form 61 is the one that was used previously for ex parte orders. That still calls it objection and motion to rescind. And the question is, when will the SCAO form be updated? And you know what? I have no idea, because it seems like, in my humble opinion, they should have had a scale form before before the rule change went into effect, because this is really important. Like, people are relying on
Well,
these forms, and you know how many people are going to do it wrong, because maybe some people
yeah.
they're not here. They're maybe not paying as close attention as to everybody else that we have here today. And for whatever reason, and they might just get it wrong because they aren't even aware that there's a new court rule. And then if
Hmm.
you are aware of the court rule, you're looking at the form like, what am I supposed to do with this? I don't know how to fill it out.
Hmm.
So I don't
Right.
know the answer. Hopefully they're
Well,
working
and
on it.
and something else about these motions and orders that are supposed to be provided by the friend of the court. If the friend of the court isn't, I'm kind of jumping down to the bottom of the chart here, but if the friend of the court isn't able to resolve the issue between the parents, then under the court rule, the friend of the court must provide form pleadings and written instructions to the impropers. I don't know that we have those. Do we? I don't know.
I don't
And
think so.
then the court, the front of the court will reschedule the evidentiary hearing within 21 days of the motion. So, I just don't know why we're having another, like, if you look at the statute, in the middle of the bottom one about if the front of the court fails to resolve, then they must provide a form motion and order, if they haven't resolved it. Okay, why are we having another motion? The reason we're
Right.
in front of the court is because a motion was filed. So why, I guess I don't get it. Maybe
It,
somebody else knows why. I'm a little bit confused about that.
does it almost seem like the statute was written to help impropers with the process?
And to me, the way I read it, impropers could get through the process more quickly because the front of the court has to schedule the hearing for pro se respondents in front of the judge if they don't resolve it within 21 days of the motion to rescind or modify. And if you are represented, then it seems to me the way the statute reads is that the attorney is filing the motion. Okay, we went to front of the court, it didn't work. Now I, as the attorney, I have to get on the court's docket and I have to, I can get on the docket within 21 days, but then the judge has 28 days to respond. So
But
it's
here we're
very
also talking
confusing.
about a lot of delay when in the scenario that I guess I've seen more because of my practice is when parenting time is suspended.
Yeah.
So I want to stop this share. I want to go back to the statute because there's a couple things I wanted to point out and we can have a little discussion about.
The statute or the court rule?
I want to go back to the court rule. Yep, that's what I meant.
Okay. Okay.
Gotta find it. Hold on. There it is. The court rule. So it talks about, so we talk about doing a motion to rescind, that keeps you what we're calling the judicial track. And then if you do an objection, you're going to go to the front of the court. Well, pause. What does that mean? It's not, it doesn't have to be a referee. You might be going in front of an investigator. And I'm very confident that some counties are, that's what they're doing because the investigators could maybe jump on it more quickly than a referee could. Probably the referee, and deciding a dispute within 14 days. I don't know. Are there referee offices that are able to do that? I would think that their dockets are
willingly is the question.
Right, but I feel like they have they already have all these referee hearings that are scheduled that you take up all their time. I don't know, but if we're in front of an investigator,
it just doesn't get that granular. It just doesn't get that granular, right? Just yet another question that is left unanswered.
Well, I'll have to say I did testify about this court rule change, and that was one of the things I brought up was like, what is this supposed to mean? Where are people supposed to go? You tell me, how do you envision it going in front of the investigator? Now you're not even having, it's not a real hearing, right? You're not going to have a record. There's not going to be something for the judge to review. They're just going to make a recommendation based on maybe meeting with the two parties.
Are they even going to take testimony? It doesn't say what the front of the court's supposed to do. They're supposed to try to resolve it. It doesn't say how.
Well,
through
that's
evidence,
right.
Through testimony.
There's a friend of court mediation process. Is that kind of what they're
Is that it? I have no idea. Good question.
I mean, I think that would work in some cases, but a lot of these cases where something's going on in the middle of a case or post judgment that causes one of the parents to file an ex parte motion to suspend parenting time, I don't know that there's going to be that's not going to be a place for negotiation.
I agree.
I don't know.
Yeah, I agree.
Okay.
And if courts have trouble getting these motions, on their dockets in a timely manner, carving that time, and here I am playing court administrator, carving that time out ahead of time so that you have a special docket. Maybe it's just a small docket, for ex parte orders, then you don't have to worry about that anymore, right?
Well, one of the judges I've talked to said, when they sign the order and then they schedule the hearing because that's what the court rule tells them to do, they've already confirmed that they have the time available on their calendar to do it, right? And then they have to cancel the hearing. So then that time is gone. It's taken up by something else. The void
and meanwhile,
has been filled.
These kids are in limbo, the parents are in limbo. And it's just not good. It's just not good. I think if there are ways that you can avoid, asking for ex parte orders, but you have to judge that on your own. But it certainly isn't something that I think every practitioner should jump to in every instance when a client comes in sort of in a panic mode, have a long conversation with them. right, about like what exactly is going on, what would the others
Right.
say, what is there a pattern here? Is this a one-time instance of something happening? Or do we have a pattern where we can really show that, there is imminent danger and harm? Or do we just does our client prone to anxiety, which so many of them are, right? Understandably. And, but their anxiety doesn't necessarily an emergency ex parte order make.
Right, right. We have one last polling question. It might be superfluous after this discussion we've had, but let's go ahead and throw it up there.
Cool.
Jacob, if you could. Sorry, I didn't give him any warning. And there's a lot of questions, so I do kind of want to go through and make sure we didn't miss anything. Having studied 3207B, do you think the Supreme Court reads the rule as a two-track process? Yes, no, how am I supposed to know? And then while people are voting, I wanted to talk about a couple of other provisions, and then I think we need to like go look at some of the questions because I know there's a lot of conversation happening right now about this court rule, and because we don't have, we haven't had that many opportunities to use it yet, or litigate it, or appeal it. We're kind of like working in the dark a little bit. End poll, and it was basically everybody agrees there's two tracks.
Oh,
I think.
cool.
Yeah.
I'm glad to hear that. I'm glad to hear that result. Because that, as they were making the sausage, that is what I was hoping for, that there would be. So,
well, we don't know if we're right. We're just saying
we don't know if we're right, but if we are, maybe it doesn't need to be changed. If, if the concern amongst the judges tends to be, well, I don't want to have to send this to the front of the court.
As long as.
And as practitioners, we get it. Okay, file a motion, don't file an objection. Seems ridiculous, but
and then file your motion such that you can tag on to the hearing that's already been scheduled.
Yeah.
Right. So there's a couple other things that I wanted to make sure we talked about in the new court rule. If there's not an objection, there's still a hearing.
Right. But here's what you could do. The very next court, 3.207C, allows for temporary orders if the parties agree. Okay. So without a hearing. Okay. So what you do, if there's no objection, work with opposing counsel. It's a concept, work together and come up with a temporary order by agreement. Right.
Well, a perfect example of that, Lori, is if there's like one parent maybe is having a mental health crisis and they know they need to have a temporary reprieve to go deal with their things. And maybe that would exactly be the situation. Yes, I agree there should be temporary suspension of parenting time because I have to take care of this thing. I might have to go to the hospital, whatever. Yeah, right. Exactly.
And here's your opportunity as that parent to say, but it needs to say that once I get out, I'm going to be able to, parent the children in whatever agreed upon way. So, yeah, I mean, sometimes it does take, right, a motion for an ex parte order to sort of get things on track in a reasonable way. And two experienced good lawyers should be able to do that. They should be objective enough to focus on the best interest of the children and the statutory requirement that all children have a significant, meaningful relationship with both parents and figure out how we can put our heads together to make that happen.
Yeah. Gregory posted a chat. I'm going to go back and look at the other chats, but he said, so file a response to the motion rather than objection. That's just my opinion. Yes, because then it gets you in front of the judge and it avoids delay. So I think that is the way to go unless you really want to go to the front of the court. Mm-hmm. I wanted to point out one more thing. Like I'm going to go back up when we're talking about here's what we're calling track 1, the motion, track 2, the objection. You notice there's times of how long is allowed to go by before it's decided once that document's filed. What it doesn't say for either one of them is how much time do you have to file it. There's nothing about a deadline for the motion to rescind. For the objection here in this part of the court rule, you have to go down and look at the notice. It's also in the statute. The objection has to be filed in 14 days, but it's strange to me it's not here if the party files a timely objection, oh, what the heck is that? Oh, okay, you have to go way down here and see, oh, there's a notice.
Yeah.
And you must file a written objection to the clerk within 14 days.
Yeah.
I think it's just a little weird. But it also is the same way in the statute. So.
Right. Well, and to your audience members' comment about response to the motion. So say you get an ex parte order and it has the hearing date in it. Okay. You know, you've already got that date in front of the judge, right? And you want your moment in front of the judge. Why not just file a response to the motion for entry of an ex parte order rather than a motion
I see what you're saying.
Rather than to file a motion to set it aside. That way you're on the record as disputing whatever allegations you may need to dispute.
But it's interesting that the rule doesn't say anything about filing a response to the motion.
It doesn't, but it doesn't say you can't.
I think I like it though, because then you make a record of what the objections are, what you think is deficient about the
And you
motion.
don't go down either of these rabbit holes. You just go to court.
Yeah, but however, like you pointed out, it doesn't say anything about serving the motion. So you may be arguing the response in a vacuum. You really don't know what they alleged unless they did happen to, do the courtesy.
Oh, you got it. You got to somehow get that motion.
Yeah,
and if they do one thing to change this court rule, it's require that the motion also be served along with the order.
I mean, that is a due process issue.
It is a huge due process.
Like, what is the judge basing it on? Oh, you said this thing, horrible thing. Like, oh, okay, well, now I know why the judge granted it. Obviously, it may not be true, but then that's where you have a chance to respond or whatever.
And frankly, Lisa, I think if somebody files a motion for an ex parte order that's denied, you should have to serve that on the other side too. You need to know what people are saying to the judge about your client. You have a right to know that.
Has that ever, I'm curious that you brought that up. Is that something that's ever done, an ex parte being denied? I mean, it's going to be in the trial court record, right? It's going to be on the register of actions. Your client could find out about it if they happen to be, at court, the attorney looks it up and could see that something was filed and denied. So they're going to find out about it eventually, even if they didn't have to serve it. But
yeah. I mean, the only way to make sure that because there's no requirement that you be notified or served, is to go check the court's website and see if one was filed.
So I'm going to start looking at the chat. You can't see the chat, right? You can see the chat on your own screen, but not the one I'm scrolling through, right? Because that's going to make everybody dizzy, I think.
Certain things are popping up on mine.
Oh, okay.
By the way, I wanted to mention, there's no requirement anywhere in this rule that the court decide on the motion for the ex parte order within any particular period of time. Did you notice that?
Oh, yeah, way up at the beginning.
There's no requirement. Like, you could file your motion for ex parte order and wait 2-3 weeks to get, and then all of a sudden you got to serve the order within 3 days. I mean, again,
aren't they usually, if they're going to be, I don't know. I'm not a trial attorney. You tell me if I'm wrong, but like the very few times I've had to go to court with some sort of thing, you bring it to somebody's bringing it to the judge is reading it and deciding right then and there whether they're going to sign it, or you bring it to the clerk, it's delivered to the judge right away.
I think in reality, as a matter of practice, I've had to go over the courthouse before, and that judge, it was a Friday afternoon, that judge was out, this judge was on vacation. It took going to 4 different chambers to try to get a motion for an ex parte order reviewed before it could get reviewed. And some judges aren't comfortable entering ex parte orders on another judge's case.
Right.
And if you do get an ex parte order from a judge who's sort of subbing in for one who doesn't happen to be on the bench, then you've got that whole dynamic to deal with. So I just feel like if somebody is making the allegations properly about irreparable harm, imminent danger, if they're going to go to the extent to file the motion for the ex parte order, the court should be required to either, grant or deny it within some reasonable period of time. What reasonable is, I leave that to others.
So going back, because there's been a lot of chat about the service issues, and I'm going to start sharing some of the comments and see if we have any responses. One person mentioned that some counties will not return the order. They will only return the order by mail. And so by the time the order is received in the mail,
the 3 days are gone.
The 3 days are gone. I mean, that's just a practical reality.
Yeah.
Is that, I mean, do a lot of people have experience with counties just mailing and you mail an ex parte order? I just mind boggling to me.
Yeah, I do believe it. I
Okay.
do believe it. Yep.
And somebody asked the court rule says arrange for service. Does that mean the service has to be perfected in 3 days or just in the process server's hands? I feel like they mean it needs to be physically here served to the person. That's what I think they mean.
Right. Now, if the case was already filed and you have opposing counsel, you can just, serve it by first class mail, or you can use, I think it's 2507 if you stipulate to serve each other by mail. You could do it that way. But as I said, if you're serving it along with the complaint for divorce and it's the initial pleading, right, then it's got to be in person.
I like this. Lisa Schmidt mentioned that she had the practice of putting in her ex parte orders a blank for the judge to put in when the hearing is going to be. Anything that you can do to help prompt the judge, because I think when they see that, they're like, oh yeah, let me go find a date. But maybe maybe that's not going to be where their head is when they're like trying to figure, like, especially with the new rule.
That is a great practice.
I think it's a great practice. Yeah, agree. Thank you, Lisa. Does service mean personal service or first class mail? Yeah, well, it's not an initial complaint. Usually, like, do you have to do personal service? You were talking about getting a process server, so I kind of like.
I mean, if you're going to serve somebody with the complaint anyway, why not include the ex parte order?
But if you have an attorney, when you just email it to them, or I mean, what about e-filing?
Yeah,
like
you can serve it by
okay.
Yeah, for sure.
Okay.
Yeah. And that's probably what they were thinking of when they drafted this, right? Is that there's already a case pending and all you have to do is e-serve and e-file.
Right.
But if the request is being filed along with the initial complaint, then that's going to be a little bit of a challenge to do the 3-day thing.
Okay. Isn't the necessity of the objection and or motion to rescind render moot by the requirement to schedule a hearing within 21 days? Yeah, potentially. That's what we were talking about. You could just file a response even though it's not mentioned because they're supposed to have a hearing even if an objection is not filed. So what's the value? If the judge has followed the procedure and scheduled the hearing, what's the value of filing an objection or a motion?
I mean,
versus just filing a response.
You might get in front of the court faster. That's one possibility because of the 14 days, right? They have to, as soon as they get a copy of the order, the ex parte order, then front of the court has to deal with it within 14 days. And that might be sooner than you can get in front of the judge. So that might be a reason why you might want to do that.
And it really depends on your practice in your county because you might be very comfortable with the front of the court office in a specific county. Even if you like the judges, you might be very comfortable with that front of the court office, and maybe you'd be okay with that. Especially if it gets you in front of them sooner. I just don't know realistically, are they going to be able to handle that? Maybe in some smaller counties. I just don't know.
Well, I mean, it's not unlike back in the time when there was a rule change that front of the court had to send out letters saying you get your child support reviewed every 2 years or something like that. It was like nobody, from what I heard, like nobody asked the front of the court if they had the bandwidth to do that. I don't know. I don't know what stakeholders from Friends of the Court were involved in drafting this. I have no idea.
Yeah, we're getting a lot of timing questions about, especially when the order is mailed and then you have to serve it and then you still have to do your response or your motion or something before the hearing. Like, I get it. Yeah, I agree. I don't know that I can answer the question. The rule does not address it. No, the rule does not address that, William. It's confusing.
Then let's not forget MCR 3.210C, when the custody of a minor is contested, a hearing in the matter must be held within 56 days after the filing of notice that a custody hearing is requested, unless parties agree to mediation. Okay, so there's that little number to throw in there too. I can count on 0 hands how often that's happened in my career.
I'm right. It's just not a court rule that's followed. I've dug into it a couple of times, and the cases that cite that part of the court rule, the 56 days, have basically said, yeah, the court violated this, but oh well. It eventually made a decision. I'm like, okay, well, I mean, 56 days, like, can you imagine trying to resolve a custody dispute in 56 days when it's but
Yeah,
a year and a half is too long, maybe 56 days is too short. So I don't know.
right.
I'm just going through the questions and making sure we've got everybody.
And and another, as you're going through those, kind of popped into my mind that now that we're in sometimes in a Zoom world, sometimes in a hybrid Zoom in court world, depending on where you practice, um, that is an opportunity again to have a bespoke docket to deal with these, right? Like, because it's just more efficient, I think. Now, there are a lot of reasons why, Zoom hearings are undesirable from a due process point of view, that's for sure. But in these instances, we are talking usually about a real hot potato that we're really trying to the court's trying to get their arms around and sort of get control over quickly.
We have a few more questions about why a separate motion is, this is Mark Crane, about why a separate motion is preferable, but am I correct that utilizing a separate motion with a supporting affidavit will necessitate notarization, whereas verification can be accomplished without the involvement of a notary? Oh, interesting. Because you verify it by having your client sign it? Is that when you have a verified pleading, it doesn't have to be notarized? But they said the
Right,
court rule
usually
says
you
you can use
just,
either one. I mean, the court rule says either one. So like whatever,
yeah,
yeah. So I think you just have to pick which way is going to work for your case and your client. If we
yeah,
allege that it, oh, sorry. If we
I,
allege that it won't change the EC, does the court still have to schedule a hearing? Well,
it depends what the court decides. The court could disagree with you, right? And say, you say it doesn't change the ECE, but I think it does based on what you've written in your motion.
I mean, the court rule says a court may not issue an order that will change, that could, not will, but could alter the ECE without scheduling a hearing. So to your point, let's just say the judge says, no, this is not going to change the ECE. I think they could issue the order. They may not have to set the hearing right then and there, but there's still going to be this opportunity to object or file a motion to rescind, right? So the hearing has to happen if it's a change, if it changes, if it could change, let me rephrase it. The hearing has to happen if it could alter a child's established custodial environment.
Right.
That's how I'm reading it. I mean, I know it's two different.
Okay, so here's my question. If the order you're seeking isn't going to change the child's established custodial environment, why are you having to file an order? I mean, you probably have the kid, right? I mean, maybe the parent who has never been around the child, like, and the child is 10 or something, decides on a whim they're going to go, kidnap, so to speak, the child. Right now, there's no change in established custodial.
But it could be a situation where the primary parent, maybe the other parent only see the child once or twice a month, and then something's going on with that other parent that makes you worried about the safety of the child. So having that ex parte order it's going to protect the safety of the child, but it's not going to change, or it's not really going to have the potential altering the ECE by just taking away maybe 2 overnights or 2 visits a month temporarily. There's still going to have to be a hearing eventually, right? It just if it doesn't alter the ECE, then I think it does change the process a little bit, I guess.
Right. But again, it's your judge is going to have to decide whether they think, just because you say it doesn't alter
Right.
ECE doesn't mean it doesn't, according to the judge's perspective.
Right. We do have
some judges have a pretty kind of low bar for what it takes for a child to have an established custodial environment with a parent, right? I mean, every judge has sort of their own sliding scale of this is what it takes.
Right. Well, I think what we can conclude from today, and there's still a lot more chats, I can't keep up with them right now, is that there's a lot to this rule. If you're doing a motion for ex parte relief or responding to one, I mean, just please, I guess, read the rule multiple times. Try to find out what you can about the court's process for the county you're in. Do you have any other tips?
I think even, I don't think it's appropriate myself to talk to judicial attorneys about cases in particular and the facts. I think that's not okay. But I think calling a judicial attorney and asking, has your judge ruled on any motions for ex parte order under the new rule yet?
Mm-hmm.
And how are they processing those? I mean, that I think that can't hurt, right?
Would you call the judicial attorney for that or the clerk? Maybe
I would call a judicial attorney, because from one chambers to another, they could be doing it differently, Yeah.
Find out what the process is that's being used. And we're going to find out more. I don't know if we have any ex parte order topics at FLI next week. I don't think so, because this all came about after all the planning was done for the Family Law Institute. So I don't know, maybe we'll have something in May at the AML seminar, because I think we need to see how the counties and the judges are handling this.
Spoiler alert, I think we will. I think I'm going to be talking on this in May.
Yay, awesome. I'll be there.
Okay, so here's my email address. All of you who are on this or listen to it later, I would love to hear your experiences as this role plays out, right? Mm-hmm. And I would really welcome you to email or call me. So it's my last name, Buiteweg at NSSSB, like Liisa said, .com is the easy way to remember my firm's name.
Well, and we're going to send out takeaways in the next couple of days, which will include the chart that Lori made for us and the red marked, the lined up court rule that the Supreme Court issued, so that you'll have some little bit more details as we can start thinking about this and trying to do the best we can with what we know. And everybody's trying to figure it out. It's not just us. So.
And you may get an email from me, if Lisa's allowed to give me the list of attendees, asking if you've experienced, any of this, and if you know of anybody else who has, because when I do the presentation, which I think I'll be doing in May for the Academy, I would love to have that anecdotal information.
Yeah, I think it's May 7th is the Academy presentation, and I think it's really going to be valuable to have that on May 7th. And we're going to have at least, we'll have like 8 months or 9 months with the court rule.
Yep.
We're not going to have any cases yet from the Court of Appeals, but we'll maybe have some practices that have been figured out around the state. So, Lori, thank you so much. I know this is a hard topic because we have so many questions, but it was so great to have your insights. Thank you for everybody. Tons of participation today. I appreciate it. I'm sorry I didn't get to look at all the chats. We'll save them and make sure I didn't miss anything that people have questions. We'll do our best.
Okay. Thank you, Liisa.
Okay. Bye-bye.
Have a great afternoon. Bye-bye.